it's a great part about Broward and Miami. They have a lot of watchdog organizations. Our Broward Association of Criminal Defense Lawyers has a list basically of officers when they get in trouble, when they get anything, and it's this list that we've compiled. So you go to it and you're like, okay, does anyone know anything about this officer? People will send you the dirt on them. It's great, and a lot of counties don't have it.
Could you comment briefly on the NSA DEA cooperation regulations and just how many of your cases
that
do you
doesn't
think
exist,
have been
does it?
I mean,
I can't comment on that because it's really just outrageous, and it's you know. And from my perspective, okay, a lot of these grow houses these days, how do they get them? Anonymous tip. Okay, it's an anonymous tip. We have no idea. We walk up to the door. Now we smell cannabis at the house. Now we get a search warrant. And to be able to challenge these types of things with the information from the SOD and stuff like that would be invaluable. It happens a lot with confidential informants. They don't want to disclose the information about a confidential informant. Well, I had a guy in St. Lucie, they busted a guy for trafficking in pills. He had like 4 counts of trafficking in like 4 different types of pills. Well, the undercover cops, to get this guy a lighter sentence, the guy who's trafficking sold 4 pills to my client. 4. And they arrest him. And so the guy who's trafficking is going to get a lighter sentence because after 2 months, my client agreed to buy 4 pills. And that's what that's what law enforcement's doing. And that's the only way they bust people is really tips. Either anonymous tips or snitches, or really all these snitches and anonymous tips that could be this SOD now. We don't know, and they don't provide us that information. I think it's disgusting. It's an absolute affront of our constitutional rights. It's them withholding what I would consider as invaluable information. I'm lucky I have a case right now with the tipster came to me and said, listen, they threatened me with guns. They said they'd take my family away. They'd take my house. They'd ruin my wife's career. You know, and meanwhile they're holding an AK-47 at your head, you know, and he flipped. He ended up talking. But when they filed the search warrant, they didn't say one thing about, they said a cooperating witness. Like he's just this nice guy off the side of the street that's like, hey, there's a grow house there, let's go. You know, so I'm hoping to get that case thrown out based on that. But it's what these cops do. They lie and they hide as much as they can. I'm asking the cop about this in the deposition. He starts getting pissed at me. How do you know this information? What's going on? Why are you asking me these questions? I'm like, I'm the attorney. I'm asking you the questions. You answer them. You know, I don't. You can't take shit from these cops. Yeah. Excuse my language. You just can't, because they will walk over you if they can. You know, it's kind of like my son. He's 3.5. I don't know if you were here for the opening, but you know, you give him an inch, he takes a mile. Yeah. So, and that's exactly what they do with the door opening. And I'll go back to that because you asked about plain view. With the door opening, okay, and what cops will do as they're walking up to your car, most likely, especially if they're multiple, they start at your back window with a flashlight and they're looking at every nook and cranny, everything that they can see. Plain view is basically just that. If they can see something in plain view, they have a right, and they immediately know it's contraband, they have a right to seize it. Okay, and that includes a house. If they're in a spot that they're legally entitled to be, if something is in plain view, they can seize it, they can arrest you for it. That would create, say, there's a bowl in your console or something like that, and it looks like it has residue in it. I'm going to say that because I would argue if it didn't have residue, they couldn't tell, then they can't say it's paraphernalia. But residue or something like that that they see, they could potentially then get it. That's a right for them to search. A joint, unless they have the odor, is not sufficient. Okay?
You can go out and buy tobacco and roll
Tobacco,
cigarettes.
right.
Exactly.
I don't know what tobacco is.
Exactly. Typically, that's not sufficient for them to do a search.
But you think if they come into my backyard through my fence where it says, and they look in my back
I'll get to
window and
houses.
see my tray.
I'll get to houses.
Okay.
Has to
I'll
be
be
visible
patient.
from a public space.
Everybody
Or
patient.
they have to have a warrant.
So number 2, we'll do a person, okay? Because the car's number 1, number 2, a person. You're walking on the side of the street, anywhere. Cop says, "Hey, stop." Do you have a right? Who thinks they have to stop?
You
have
told
to
me
stop?
no.
I don't have to stop.
That's right. You can keep going. Unless they have reasonable suspicion, they have absolutely no right to detain you. And as soon as they touch you, as soon as they order you to stop, that's a detention. Okay? That creates a custodial interrogation, meaning you are no longer free to leave. They have to prove, okay, and what I would do is I'd file a motion in the court, and they would have to prove that they had reasonable suspicion to detain you. Okay?
So if I'm no longer free to leave, then
What
I
is
don't have
reasonable
to
suspicion?
Yeah, the gray area to me is if they say stop, if I'm saying stop to you, how do you know whether I have reasonable suspicion until what are you going to say? Do you have reasonable suspicion? Or do
Well,
you just keep walking
Again,
Matter
I would
whether or not
keep
he ordered
walking.
you, right?
I
With
would
all
keep walking.
innocence.
until he detains you?
Correct. Let him come up and put a hand on you, because that creates, it could be a 100-year-old, and this is a sad thing. Okay, they do have a right to tase you. If you're in handcuffs and you're running away from the cops, they have a right to tase you. It's sad, but it's true. They have a right to tase anyone, either violence against themselves or someone escaping. I think it's disgusting. I don't know if any of you have seen the video. There was a video of a girl that was like 100 pounds, and she had a driving while license suspended charge, and she tried to run. She got tased. I don't know if she's dead or she's still in a coma. I know she hit the ground hard. She hit a curb. She was in a coma for a long time. I don't know what happened with it, but they do have a right to tase you if you're escaping an unlawful arrest or something. The big issue is, again, what is a lawful stop and a reasonable suspicion of a stop? And that's a very gray area. But technically, if you're just walking down the street and you're not committing any crimes, you're not smoking a joint or anything that they can smell, they have to have something. They have to have some evidence. And if they don't, as long as you exercise your rights and don't consent to a search and don't consent to stopping, because 90% of people think they have to. Cop says, hey, come over here, you have to do it. You don't. You don't. Most people don't recognize that. And yeah, is a cop going to possibly give you a hard time about it? Yeah, they might. But I
When
don't
does it
care.
become an order?
Right. If it becomes an order, it becomes a custodial interrogation.
Does he have to say, I order you?
No. Technically, the standard is whether a reasonable person would feel that they were free to leave. Unfortunately, the reasonable person, as defined by the Supreme Court, is someone with was me. Someone who knows the law and someone who has the guts to use it.
Right.
Right.
Because it's not a reasonable person. I read the case law and you're like, really? 90% of people have no clue that they can tell a cop to, go away. Most people feel like if a cop comes up to them, especially on the street, and the same thing, I had a case that you're walking down the street and a cop gets in your way, and you have to go around them or move your path. Technically, that can be considered a seizure, okay? Because they are impeding your path. And especially, and then if they make any verbal commands or questions to you, that's a seizure. And again, the importance of the seizure is it sets the tone of the interaction, okay? When you don't have a seizure, you have no right to your Miranda rights. You have no right to leave, and basically the cop's going to say everything you did was consensual. If it's consensual, it gets in. Okay, if it's consensual, it's an arrest. Okay. What is consent? Okay, consent is technically knowingly and voluntarily waiving your rights or agreeing to do what they want. So if you create that custodial interrogation and require them to define it, because most of the time, if the cop knows they have no reason to stop you, they're not going to do it if you keep walking. They're not. If they have no reason, because you know who's opening up themselves up to a lawsuit? They are.
They are.
Because if they stop you and arrest you for that, that's false imprisonment. Okay, you have a lawsuit against that. They have rights. They know you have rights. They're just going to try to make sure that, or make you feel that you don't. That's what they're trying to do. Okay, so on a consensual encounter, definitely try to walk away. Ask the officer specifically, am I free to go? Can I leave? Are you detaining me? If they do a pat down or anything that's unusual, that then again is another factor that the court's going to consider whether or not you're in custody. Again, cops should not be doing this. What they'll do regularly is pull people out of vehicles and automatically pat them down. They should not be doing that. It's not legal. Okay, but they do it on a regular and consistent basis. But the courts have regularly said, you can't just do it as a matter of routine. You have to have some sort of reasonable suspicion. And it doesn't matter if you're in a public place or a private place or not. You have no obligation to talk to a cop as a consensual encounter. And that's the same thing. And say it happens a lot if you're in a parking lot in a gas station, you're sitting there waiting for someone. Just so you know, there's typically always probably a half a dozen to a dozen, depending on what county you're in, undercover cops rolling around gas stations and things like that all the time. I've had numerous cases, cops are allegedly just sitting there waiting, and they see someone come up and use a cell phone, or two people not use gas and not go into the gas station and meet up. You know, they're going to stop you, okay? Don't do stuff like that, okay? It's best to keep things in your home if there's any transactions. The home is the most difficult place to get into, okay? It's the most important place, too. And they need a warrant to get into your home unless they have consent or exigent circumstances, really. Consent is obviously consent, same thing that we've been speaking about. Exigent circumstances. Say there's a call about domestic violence, and they think someone in the house is dangerous. If they come there and they say, we're looking for drugs, and they hear the toilets start flushing, they may say that's exigent circumstances because they have to get in there to prevent the destruction of evidence. When they come to your home, the most common thing that they're doing these days is called a knock and talk, okay? They have an absolute right to come up to your front door just like anybody in the public would and knock on your door and talk to you. What they're doing, one, looking for odors, okay? What I would suggest is if a cop ever comes to your residence, it depends on how your house is situated. Personally, I have 2 dogs. I would use the excuse that, listen, I'm not coming out my front door. I would go out my garage side door and go around and talk to them that way. Okay, go out and meet them. Don't let them force their way into your house.
Do you have to answer the door?
No, absolutely not.
Okay.
Absolutely not, you don't. That's a good question. No, you don't. No, absolutely no right.
And you don't have to answer them through the door.
No, you do not. There was a case that just came out probably within the last couple weeks from an appellate court. And when I talk about appellate courts, okay, the trial courts are down here, and that's when you get all your facts and things like that. An appellate court is a court that reviews, kind of like a boss, and makes sure that the trial court did everything correctly. So most of the case law that we have as to how the law is, what is a consensual encounter, what is not, comes from these appellate court opinions. The appellate courts just recently held that there was a guy who cops came up, like knocked on the door. They basically came out for a second, saw it was the cops, shut the door, and went back in. Yes. And they said, nope, you cannot go in after him. That's an illegal search. They had an absolute right to do that. That's not reasonable suspicion of criminal activity. So you absolutely have no right to, no obligation to.
There's that cop, I guess, I think it's in California, an ex-cop who's kind of teaching on that type of thing, and he watched this video. He said, he yells through the window, he says, I'll talk to you through the window, or you can call me on my phone. I don't open my door for police.
Yep.
That sounds like Barry Cooper.
Call me on my phone, or I'll talk to you through the window here, but I'm not opening my door for police.
In the extreme case in Florida, just recently, the guy opened his door in the middle of the night because the cops knocked on his door, but had the wrong house. And because he answered the door with his gun in his hand, they shot and killed him. To protect him. He was just protecting himself, opening the door at 3 o'clock in the morning. He didn't know it was the cops because they never said this is the police department.
Well,
So he opens the door and they shoot him. So in the extreme cases, it's best just to
right.
not
Go
open
away.
the door for anybody.
Yeah, it really is, and for your protection, especially with these days, the rise of home evasions and stuff like that, I would absolutely.
And they'll keep knocking.
Out your window.
They'll knock for a long time sometimes.
Yeah, they
Feel
will.
so empowered all of a sudden.
And another case also just came out and said that they can't. Typically they should go from, the access point to your house straight up to your front door. There was a case recently, they said the guy had peered around a window like this to look in, and he saw a bomb. They said that was an illegal search because he was diverting his eyes from what a normal person, the normal public would do.
Not clean.
Now,
Interesting.
I'm saying a lot about fighting these cases and defending them, and I want to give you, these are generalizations mostly, and number two, a lot of times it depends on the judge you have. This case, unfortunately, I have in Pasco County. That's the one the judge found a no trespassing sign, a chain around the fence, and a beware of dog sign, and a fence around this whole property was okay for the cops to open that fence and drive onto his property and go talk to him. So the appellate courts are needed. Obviously, that will be appeal eventually. Hopefully, we win the trial and we don't have to worry about it. I encourage everyone to support Mr. Alfred Robinson next week. Medical
Tomorrow,
necessity
with
trial.
a call on.
Yes.
You should have it in your email when you get home.
Please do. It's going to be should be a great day for this.
Call prosecutor.
For this event. Yep, call the prosecutor's office. And Jody did say it before, and I didn't get to it, but there is an option C, I believe, to changing the laws in the state of Florida. I file a motion to dismiss in most of my medical cases and cannabis cases, arguing the constitutionality of cannabis as a Schedule I substance. Basically, I say there is absolutely no rational basis for cannabis to be a Schedule I substance based on X, Y, and Z. Hoping, praying, I have a judge that in Broward County who I've been to or seen him at Further Festival shows, fish shows, Widespread Panic shows. I don't know if anybody knows who any of those bands are.
Right.
He was a public defender for a while. He's called my office twice asking for a copy of the motion, and he set it down within like 2 weeks. So I don't know. I'm hoping that he has the guts to do the right
Yeah.
thing.
When was that?
It's August 26th.
Oh.
We have the hearing.
We'll send him a fan mail.
Yeah.
We're keeping it quiet. Well, technically, what would happen is if he did have the guts. He's a new judge. He's been a judge for less than a year. When I first saw his name, I actually thought it was his dad. Because this kid was a public defender. I can't imagine. I'm surprised he got elected as a judge. Mostly they're state attorneys. Technically, if he grants my motion, at least in Broward, there should be precedent that cannabis is now an unscheduled substance.
Nice.
So that's my goal of it. And then it would go directly to the Florida Supreme Court because it's declaring a Florida statute unconstitutional. If anyone has the guts to do it, I think it's him. I actually think the state may drop the case before we even get there because they're afraid that he'll do it. That would be great too, but I'd really like to get him to rule on this motion, obviously in our favor, but I don't know. I'm a strong believer in it, but it hasn't, the judges that we have are very conservative, and people put politics over medicine.
If he does do that, and then it's entered into case law, and say something happens here in Brevard, can it be cited to that?
Absolutely.
Yeah, Florida Supreme Court.
Technically, our whole drug laws are actually under appeal right now. There was a case, a federal district court case out of Tampa, which declared our drug statute unconstitutional. The Florida Supreme Court said no, that federal case isn't binding precedent, so the drug laws are constitutional. They have appealed the federal case, to a higher court, and we'll see what happens, but we are challenging it right now based on a few different things, and so you never know. I personally think the federal court should rule because it's based on a federal question of due process, not based on state law, but we'll see. The federal court did declare it unconstitutional. So Miami, they threw out like 500 cases for it when that happened. So
Are you
that
still
would
trying
be
to
the
pressure the Attorney General to just
Pam Bondi?
reschedule it?
I've had cases with Pam Bondi. Let's just say that she's pretty cold-hearted, and she's
We
a
have
prosecutor.
petitioned her.
She's a prosecutor through and through. She is a prosecutor through and through. That's all I have to say about her. But I've unfortunately had dealings with her, and she's a prosecutor through and through. So your house. Put up no trespassing signs if you can. Fence your property if you can. I know Florida is the home of the HOAs. Those things are very difficult. But any intention technically in order to let the public know that they are not wanted on your property should be sufficient to keep them out depending on your judge. So I would say to do that, to protect yourself, give yourself a cushion. If you can fence your property, do it. But create that cushion of people. Now, when they come to your house, this is the thing that they do all the time. We will get a search warrant. Fine, go get one is your answer.
Right.
Okay? Because if they're there knocking and talking on your door, they probably don't have enough evidence to get a search warrant.
They'd have brought it with them.
Right, because they ain't going to come and do a knock and talk if they have enough evidence to search your house,
Okay.
to get a search warrant. So don't let that happen.
I've heard a thing called curtilage that's kind of, if you have 10 acres and you have a fence around your 10 acres, then you kind of don't have any privacy anymore because, I don't know, can you explain that briefly?
Curtilage is technically the area that they basically consider immediately around your home, your basic general living space. Usually, depending on where it is, it'll include your house. If you have a screened-in patio or something like that, it'll include that. But yes, there is something called the open fields doctrine, and that's probably what you're kind of considering. If you do have 10 acres, and they can come, walk onto your property, not by going onto your property, but from a neighbor's, and they can look onto your property in that back 10 acres. It's called the open fields doctrine. This is an open field. You're not preventing anyone from being there. They have a right to look at it. With no trespassing signs up and stuff like that, it should help prevent it. Not have any, anything in plain view from those angles or locations as well.
If it's a fence, they can look over it or can't?
How high is the fence?
Gray area, isn't it?
Technically, there was a case out in Tampa, a great guy, his name was Gary Cole, and they actually took down a bunch of cops in Tampa. They were setting up stairs, like cinder blocks, buckets, to look over people's fences. That's a trespass. That's a trespass. The standard is basically anything that a normal citizen could do is what they can do.
That would be prowling for a citizen.
Exactly. And that's my argument to the judge up in Pasco County. Judge, if any other citizen walked onto this property with a no trespassing sign, they would be arrested or they could be shot legally. And there's nothing they can do about it. Oh, no. It's okay.
No, there's an option.
His daughter testified that she honks the horn or calls and he comes and opens the gate for her. And that's how everybody gets onto the property. But yet it was totally cool for the cops to just open the gate and go on. So that really depends on the judges you have. Unfortunately, a lot of times in this case, most of the time, as a defendant and as a cannabis user, it's the same judge that called our "I'm a patient, not a criminal" shirt paraphernalia. She said a shirt with a pot leaf on it was paraphernalia. So
That's ridiculous.
and
Yeah, it's
talk
technically
about
like
appellate
freedom of
courts.
speech or something.
That's what I try to argue. Appellate courts are also judges, and a lot of times they're biased as well. They gave me a one-word denial when I appealed and said that he should have a legal right, a First Amendment right, to wear that shirt into court. And I can't do anything with the one-word denial. I can't appeal it to the Florida Supreme Court. I can't really go to a federal court with it. I got nothing. The only thing I can do is ask them, can you guys please write me an opinion because I think that you're wrong? And they can say yes or no. But I have no other power than that. It's disgusting.
Back to driving for a second. A cop can give you a breathalyzer for no reason at all just because you're driving, right?
No.
No. Okay.
Well, yes. Okay.
Say you take a
Technically, they should have
breathalyzer
reasonable
and
suspicion.
you're at 0. What if they still want to take your
Urine.
blood or urine?
Blood is usually very, very extreme circumstances. They can use blood, bodily injury, or if you're already a medical facility or something like that, or it's impossible or impractical. They'll ask you for a urine.
Yeah.
They should have reasonable suspicion of something other than alcohol or some reasonable belief to believe that you're on drugs in order to do a urine test. They have to have some suspicion of it. So if cannabis smells in the car, they find cannabis in the car, that may give them reason.
I think you're just not acting right.
Right. Okay. Green tongue, tremors. What else? Eyelid tremors as well. These are 3 things that the cops say are signs of cannabis use.
What?
Yes.
What's a green tongue from?
Yes. Smoking too much cannabis.
That's a lot.
Tremors.
There's a lot of crap out there that
Yeah.
cops get that go around these emails and stuff like that. These are coming from some of the medical states, but these are alleged signs of, obviously your red eyes and stuff like that. But these are signs that cops are told to look for of cannabis use. And I had it in Brevard County. My client pulled over for a DUI, and that's what they said. They said she was having eyelid tremors and spasms in her calves or something, and that was indicative of use of cannabis.
Don't eat those green Jolly Ranchers.
Yeah.
No, green apple
M&Ms
gum.
Right.
The absurdity of some things is amazing.
It is.
There was one guy who got arrested, and he unfortunately was a legal MS patient. This was 2 years ago. The judge, Angel Hernandez, the judge basically looked at him and said, I don't believe you're using cannabis for MS. Denied our ability to have a doctor come and testify. But the cop pulled him over or stopped him because he had installed his own rear view camera. because one, he had pain from MS. It was difficult for him to turn around and stuff. Well, the cop got an email blast saying that people who install their own rear view cameras are probably drug dealers because they want to know who's coming behind them so they can get out and shoot them. So that's why he stopped this guy.
Because he saw the rearview mirror.
The camera, right? It was
Which all new
self-installed.
cars have now.
Right, which was self-installed at the time with the kid who was with MS. He denied
Yeah.
consent to search 3 times, and they found like 3 joints in the car.
Well, what is to stop my doctor, who I'm going to go to tomorrow, and say, get your act together and prescribe some cannabis for me? I
Federal law.
hurt. What's
Federal
to s-
law.
Well,
There's no. You
but
can't
somebody
get a
has to
prescription.
start doing it, don't they?
They can't. He's going to get his license pulled. None of them will do it. They don't do that in legal states.
There's no doctor.
Really?
They even have
Yeah,
them run
they-
from prescriptions.
in
now.
legal
Forget-
states-
forget-
In legal states, it's called a recommendation.
Right.
Yeah.
They cannot prescribe cannabis.
They're even afraid to prescribe prescriptions.
And even in legal states, in Vermont, which I'm assuming everyone here thinks is a pretty liberal state. Well, they're not. They're not at all. From what I understand, what's going on up there, they've passed medical and they've had medical for a while. They're going towards decriminalization. But cancer patients up there can't get a doctor. Doctors don't have the guts to come out and write recommendations for people there.
So it's a recommendation, and then they can go to a dispensary
Correct.
and get it with a recommendation, but not a
Correct.
doctor's order.
Is there any other drug like
It's a
that?
doctor recommendation. No.
Yeah, is there?
Okay,
No.
just checking.
Right.
No, not-
While we're talking about precedent.
no, absolutely none.
I got a question going back to the houses. This whole idea of searches and everything, is it abridged at all if you're on a rental property? Or can they go around that by talking to the property owner?
No, absolutely not. And the question is, and it's reasonable expectation of privacy. Even overnight guests at a place can get a reasonable expectation of privacy. So no, landlords and stuff like that does not.
Make sure in the lease it doesn't say.
Right,
that
well,
landlord is
normally
allowed to do
it doesn't say at
searches.
least, I just wonder if they, okay.
Well, but even
But
so,
law
in most
requires
leases,
to
they
have
should
to
have
be
24-hour notice or something like that.
And that's
But a-
usually
But a
worded
landlord
into
has
the
absolutely
contract,
no
right?
right
The law requires it
to
to
let
be.
them. And even if you're in a house, jointly occupied house, say you have a roommate or something, that roommate can't consent to the search of your room.
In the video, it was there, and it said that when the person who doesn't own the house consented to let them in. What if, like, we don't have a doorbell or anything like that? It broke years ago, and we haven't worried about fixing it. Anybody knows this is going to call if they want to come in. But the neighbor routinely is like, "Oh no, that doesn't work. Go ahead and go in that part and knock on the sliding glass door or whatever."
Are they
she's
in?
given them permission to enter our home.
She can't legally.
It's not her home.
She can't legally do that. What the cops may try to argue, what the state may try to argue, that it was practice and routine for people to do that. So therefore, for example, if regular everyday people had the right to do that or did that on a regular basis, then they could say it was regular for them to do.
So I just tell my neighbor, "Don't ever do that again."
Right.
Right.
I don't care. If
So,
they come and
like,
knocking and I'm not there to answer them, it's because they're not wanted, right?
Like the same rights as the FedEx guy or the UPS guy.
Yeah, absolutely, absolutely, and that's a big, and even that case I have out in Pasco County, one of the big factors is his mailbox is outside the fence. So a mail person does not ever have to go inside the fence to drop off their mail. So those things, but absolutely, like a mail carrier, like any solicitor, traveling salesman or anyone. We will have another motion coming up actually.
Jehovah's Witness.
It's very similar to this, where the cops allegedly walked up to the garage first, took a sniff at the garage, and then proceeded around to the front door, after they smelled cannabis. So
Allegedly.
Allegedly, right, because there's no way they smelled cannabis.
2 more questions. Time for 2 more questions.
Yeah, well, could you explain a little bit? All right, I'm going to lump 2 and 1. So someone else could ask.
Wait a minute. No, you got him on speed dial. Let's
Compound question.
He's
One's a
on
clarification,
staff.
the other one's a question. So to clarify, where does, because you talked about trial court, appellate court, where does the circuit court fit in all that?
Circuit court is trial court.
Oh, okay,
Yeah.
cool.
Basically, in Florida, there's circuit court and county court. If you're charged with a misdemeanor or traffic criminal, most DUIs, you go to county court. If you're charged with a felony, you go to criminal court.
Okay, and where,
And
how
I'm
does
sorry,
jury
circuit court.
nullification fit in all that?
I'm not allowed to say it.
Yeah,
I'm not allowed
Oh,
to
really?
use that
He's
word.
an attorney. He's
Okay.
Technically, you know, it depends. Jury nullification is not something that's legally allowed to be argued in this state to a jury. There has been cases where people have gotten arrested for handing out jury nullification information pertaining to a particular case.
So First Amendment time for that one?
It's no such thing.
Well, however,
You and I
you
can
can
talk about it
educate
because we're
the
not
jury
on the bar.
pool
Correct.
about their right as a juror.
Ah.
And one of their rights as a juror, even if it's not told by the judge, one of your rights as a juror is to nullify a bad law. And that's why Florida Cannabis Action Network has created the paper that you can get online about passing out for jury nullification. So if we had someone in our group, I were to get arrested, God forbid any of it would happen to you, all of you would join me at the courthouse every Monday morning for weeks and weeks and weeks and weeks and weeks and weeks and weeks before we went to trial, where we would be passing out the same information that we would be passing out on the Monday morning when they were picking my jury. And then it's a routine practice for us to be out there, and we are not tampering with a jury. We're tampering with every jury.
Right.
Well,
okay.
yeah, and even, you know, when you're talking about a general jury pool, you know, they have no idea whether or not that person's going to be on a civil or criminal case or whatever, versus if, you know the 6 jurors that are on this trial and you go.
I have a quick question. If you're on the stand and they say something about the marijuana law, and you look to the jury and say, it's up to them to say whether that law is just or unjust, can the judge actually tell them that's not true?
It's a good question. I guess we'll find out. But you know, what the judge would probably instruct him is the standard instruction. You are required to follow the law as I had given it to you, as I instruct you on it. And it's the most common question that prosecutors ask in jury selection. And if you say, no, if I don't agree with the law, I'm not going to follow it, you're gone.
Right.
You're not a juror. And it's going to be, and I'm very curious as to what's going to happen Monday, whether or not, you know, how this jury selection process is going to go down for this medical trial. One, I mean, it seems to me most people are biased one way or the other on cannabis. If someone is biased against cannabis, I'm going to want them excluded from the jury. If someone is for cannabis, the state's going to want to exclude them from the jury. So I don't really, it's going to be very interesting, I think, how this is going to happen. What the judge would do if a witness on the stand said that is probably the state would object, the judge would, and they should move to strike. Strike the statement, the judge instructs the jury disregard the last statement that he made. But they do have that right.
You can say it's not true, though.
It's a tough question. That's a very gray area because technically, you know, they are required to follow the law as it's given them by the judge.
One more question.
Ooh. So when I look at mugshots from Brevard County, I see an awful lot of people that are arrested and the only thing that they're charged with is possession of 20 ounces or less.
20 grams?
20 grams or less. And I'm thinking to myself, what? Because you know they like to pile on any kind of charge that they can. So what in the world, do you have any insight on what these people are doing that they get caught up in this and for nothing else? I mean, are they walking around the streets and...
Mostly 90% are traffic stops, I would say. Maybe a handful of on the streets. You get some people are hanging out at the beach and stuff like that, but almost all of them are traffic stops. Or maybe they execute a search warrant on the house and you just happen to be there and you're one of the ones that get searched and you have a little cannabis on you. But 90% of them are search warrants. I'm sorry, traffic stops. Yeah, that's by far the most common. And again, that's why I can't emphasize enough, don't give them a reason to stop. You know, you're never in a rush too much to make sure that car comes to a complete stop at stop signs. Watch the stupid line that seems to be like hot between them, the cops now. I mean, I hadn't had one in 10 years someone get pulled over for that, and I've had like 3 in the last year. And it just seems to be something new. A lot of times...
I got a ticket for that damn fog line.
Yeah, they do that up here. They call it, not you know, violating a traffic control device if you go on, swerve into the right lane of the fog line, breakdown lane you call it. But Yeah, they'll pull you over for that. Any traffic infraction, anything like that, because all those lines on their road, all that stupid stuff is all a traffic control device technically that they can pull you over for.
You mentioned paraphernalia a moment ago, and I'm just wondering, what's the issue now that, was it Rick Scott signed a thing and said all paraphernalia is nothing?
The only thing that they did really was they added it to be a felony for basically head shops to sell something that they know is intended for illegal use. So that's, it really hasn't changed anything because it made it a felony, it made it more strict for them, so if they have some dumbass worker who says, hey, you're smoking your cannabis out of this, then they're going to get busted for it. But otherwise, you know, personally I think that they could, if they wanted to, try to make an argument that anything, there's no other legitimate use for it. I had some cops in Broward, I was in trial, and cops came in to get a search warrant signed by a judge, and they're sitting there telling the judge they were, this place called Green Thumb. It's a grow store, hydroponic store in Broward County. And they basically were telling the judge, there's absolutely no reason why anyone would buy these lights except for growing weed. There's no reason why this place existed except for growing cannabis. Like, nothing but speculations. They didn't say anything about anyone in the store saying anything, but they were just like, this is for drugs only. The judge signed off on the warrant. You know, and I'm sitting there biting my teeth and cringing like, so.
Hope they can afford to hire Mike Minardi. We promised you 8 o'clock. That was the one thing we were always clear on, that we would be done by 8 o'clock, even though we didn't know when we were going to start. For those of you who have bad backs and have been sitting on hard chairs, would you all join me in thanking Mike?
I don't, actually.
Mike is on the advisory board for the Florida Cannabis Action Network, so certainly if you ever need to get in touch with Mike, he's on speed dial here. By the way, you're number 3 on our speed dial, right after me, because no one in the office is going to need to call anybody worse than you, unless it's me. So there's who you call in terms of arrest.